The civil law and the common law tradition. Legislatures make laws by enacting bills, which judges must interpret and apply. If legislation is deliberately vague or inadvertently ambiguous, judges can choose among several different interpretations. Sometimes the choice of an interpretation overshadows the enactment of the bill, in which case the judge makes the law more than the legislature. Judges make law by interpreting legislation in all legal systems with independent courts. Judges make law in other ways as well. In medieval Europe, the king in most countries could issue pronouncements that were law, and the king's courts possessed similar powers. However, the king's courts were not free to pronounce as law any command that they wished. According to one tradition in legal theory, the courts of the English king were to examine community life and find laws as it already existed. The courts of the English king were to select among prevailing social norms and enforce some of them. These enforceable social norms were supposedly the laws of nature, which reason and necessity prescribed. The finding of a rule of law by court when the English king created a precedent that future courts were expected to follow. Superscript 1, which reads precedent refers to the practice of resolving similar cases in a similar fashion. If it is known that a court is going to resolve a dispute by applying precedent, then the disputants have a good idea what the legal resolution of their dispute might be. This can induce the disputants to settle the matter themselves against the background law that they know the court will use. Back to the text. A precedent in common law resembles a generally accepted interpretation in civil law. Precedent was followed flexibly but not slavishly, so the law changed gradually. Over many years, the king's courts found many important laws, especially in the areas of crimes, property, contracts, and accidents, torts. These findings are called the common law because they are allegedly rooted in the common practices of people. Common law is still applied in the English language countries, except where superseded by legislation. Legal history is different in France and the other countries of Europe. When France revolted at the end of the 18th century, the revolutionaries thought that the judges were as corrupt and worthless as the king, so they killed the king and extinguished his laws, thus abolishing the common law of France. A comprehensive set of statutes was required to fill the void so people would know what counts as property, how a valid contract is formed, and who is to bear the cost of accidents. Napoleon supplied them by commissioning legal scholars to draft the rules called the Code Napoleon, which was promulgated in 1804. The scholars who drafted it took as their model the Corpus Juris civilis, the body of the civil law, which was compiled and edited in AD 528 through 534 at the behest of the Roman Emperor Justinian. Thus, the French revolutionaries looked to ancient sources and pure reason for law, rather than to the more immediate heritage derived from medieval times. Napoleon's armies spread the Code Napoleon through much of Europe, where it remained long after his troops withdrew. Similarly, Europeans spread their law throughout the world, and this influence persisted long after the colonial empires collapsed. The civil law tradition, as it is called, predominates in most of Western Europe, Central and South America, parts of Asia colonized by European countries other than Britain, and even in pockets of the common law world, such as Louisiana, Quebec, and Puerto Rico. The common law tradition, which originated in England, prevails not only in Great Britain but also in Ireland, the United States, Canada, Australia, and New Zealand, and the parts of Africa and Asia that Britain colonized, including India. Besides these two great traditions, the unique history of each country puts its own stamp on the law. For example, Japan, which was never colonized, voluntarily adopted a code that draws heavily on the German civil code while yet remaining distinctively Japanese. In much of the Middle East, Islamic law blended with or displaced the law of the European colonialists. In Eastern Europe, communism bent the civil law tradition to its own purposes. Now, the post communist regimes are trying to straighten it. The common law and civil law traditions differ significantly with respect to how judge made law is justified. Common law judges traditionally justify their findings of law by reference to precedent and social norms or by broad requirements of rationality presupposed by public policy. Civil law judges traditionally justify their interpretation of a code directly by reference to its meaning, which scholars tease out in lengthy commentaries. Because common law judges rely relatively more on past court decisions, and civil law judges rely relatively more on the words and statutes. The common law system is based more on precedent than the civil law system. The difference in the pattern of justification affects the training of lawyers. The common law method is taught by reading cases and arguing directly from them, whereas the civil law method is taught by reading the code and arguing from commentaries on it. All such generalizations about the difference between the two traditions, however, seem simplistic relative to the subtlety and complexity of reality. For example, although the United States is ostensibly a common law country, the American states have tried to obtain greater uniformity in commercial law by enacting the Uniform Commercial Code. Deciding disputes that fall under the Uniform Commercial Code in America has many similarities to deciding disputes that fall under the French Civil Code. Additionally, the American Law Institute, an organization founded in the 1920s, meets periodically to restate the law as it is emerging in the various states. These restatements, such as the Restatement Second of Contracts and the Restatement Second of Torts, serve a similar function to the codes that are thought to be characteristic of the civil law countries. Comparative law scholars vigorously debate whether the differences between civil and common law are more apparent and real. Besides the difference in history between common and civil law, the laws are applied differently in the two traditions. In the common law countries, the arguments for the two sides in a dispute are made exclusively by their lawyers, and the judge is not supposed to direct a line of questioning or develop an argument. In this adversarial process, the judge acts more or less as a neutral referee who makes the lawyers follow the rules of procedure and evidence. The principle underlying the adversarial system is that the truth will emerge from a vigorous debate by the two sides. In contrast, the civil law judge takes an active role in directing questions and developing arguments. In this inquisitorial process, the judge is supposed to ferret out the truth. The lawyers often have to respond to the judge rather than develop the case themselves. The principle underlying the inquisitorial system is that the court has a direct interest in finding the truth regarding private disputes and crimes. Another difference between the two systems concerns the use of juries. Juries were commonly used in common law systems. In America, either party to a dispute usually has the right to a jury trial, although both parties sometimes waive this right and allow the judge to decide the case. In England, the jury has been abolished in almost all civil trials since 1966. Superscript 2, which reads, except in cases involving defamation, but returning to the text, but it is often used in criminal trials. And notice the different use of civil in the preceding sentence. Superscript 3, which reads, civil law has two meanings. It may refer to the system of law in most of continental Europe that rejects common law. In addition, civil law may refer to laws controlling disagreements between two private parties, which might arise, say, from a broken contract or an automobile accident. In this latter sense, the opposite of civil law is criminal or penal law, in which actions are initiated by the state's prosecutor against someone accused of violating a criminal statute, such as forgery or murder. Thus, the common law of state contracts can be described as civil law, meaning private law or not criminal law. Back to the text. In France, however, the jury has been abolished for all trials except the most serious crimes like murder. In general, the abolition of juries is more advanced in continental Europe than in some common law countries. In a common law trial before a jury, the judge is supposed to decide questions of law, whereas the jury is supposed to decide questions of fact. In every legal system, laws form a hierarchy. The Constitution takes precedence over statutes. The statutes usually take precedence over rules issued by the executive or government agencies. In countries with common law, statutes take precedence over it. Taking precedence means that the higher law prevails in the event of conflict. The courts, as the main interpreters of law, must decide whether laws conflict. We have complained that judges make law indirectly by interpreting statutes or codes. Another way that judges make law is by finding a conflict between laws and setting aside the lower level law. Finally, judges make common law directly in those countries that maintain the common law system, a process we explain later in this chapter. Constitutions are necessarily general and vague, so their interpretation is especially problematic. The power to review legislation for its constitutionality gives courts the power and principle to set aside laws enacted by the legislature. This power is potentially dangerous because it brings judges into conflict with the elected representatives of the nation. The extent to which this power is exercised varies greatly from one country to another. In the United States, the federal courts have few limits on their ability to strike down laws that, in the court's opinion, contradict the Constitution. Some of the most profound laws in America have been made by courts interpreting the Constitution, as in Brown versus Board of Education in 1954, which eventually ended laws mandating racial segregation of schools. In other countries, such as Great Britain, the courts do not have the power to review statutes for their constitutionality, and the courts never strike down legislation as unconstitutional. The scope of constitutional review, which is fundamental to the power and prestige of courts, has no necessary connection with whether the country's legal tradition is common or civil law.